versus the one middle. And then it'll bring everybody. If you want to do one at a time, you can do it otherwise, but that just brings everybody.
Everybody, yeah.
That's his way.
Hey, magistrates, good to see you.
Good
Good
to see you,
afternoon.
sir. Good afternoon, everybody. Good afternoon.
Okay, welcome back.
Good afternoon. So Phil's late joining us. Right, good afternoon, everybody.
Oh, there's Mr. Reagan,
So
okay.
I met him.
And then-
And EDC will be calling him that, so they're not ready yet.
Mr. Reagan, did you talk to everybody? You're on mute.
I believe we're on the last one, Judge. Are we going on live yet?
We are live, yes. Have you, we need to interview the walk-in. Do you need to interview the walk-in, Mr. Reagan?
I believe, let me just double check. No,
But he also needs to be fingerprinted.
Oh, yeah.
we're all set on Mr. Bruce.
Thank you, appreciate that.
Do we know that? Who says in the phone?
So they're gonna-
They will.
So, Mr. Burden, just be patient, sir. You're going to get fingerprinted, and then once you're fingerprinted, they'll bring you back out, and then Magistrate Burton will handle your arraignment, okay?
They're waiting for the EDC, yeah.
Yeah. So we can put ourselves in waiting.
I think we have a female that we've already done this.
Okay.
Okay,
Thank you, Mr.
yeah,
Reagan.
but thank you.
So I'm just hovering over the corner where those three dots are. And then tell DDC to bring them back however you want them. And then we'll wait whenever to the walk, but they're not back, so this.
Okay, good afternoon, everybody.
Afternoon.
Good afternoon. Good afternoon, DDC. At your pleasure.
Good afternoon, magistrates.
Good afternoon.
Afternoon.
Hey, everybody, good afternoon.
Reagan, hello.
Good afternoon, Mr. Reagan.
Good to you.
And good afternoon, Ms. Toya. Oh, they haven't connected the audio. Good afternoon, D. Oh, they're down here. There they go. Yes, good afternoon, DDC.
Good afternoon. You got a text off the screen.
Good afternoon.
Good afternoon. Okay, you can start in order, Mr.
Straight
Chairman.
down.
Yes, sir.
Straight down. Yes, thank you.
You don't share lights in the whole night. I don't see you. Don't see the whole night.
Claudia, can I get a copy of this, please?
The full name?
Buddy Turner.
Okay, good afternoon, Mr. Turner.
Afternoon.
Okay. Court is calling. Case number 25-0444-2701. The people of the state of Michigan versus Buddy Turner, also known as Melvin Burton Turner. No relationship that I know of with that last name, the same last name. Okay. Appearances, please.
Good afternoon, Samuel A. Ragnan, P23-157 on behalf of the people.
Thank you.
Your Honor, Reagan, on behalf of Mr. Buddy Turner, P57156, we waive the formal reading stand mute. Has been advised of rights, Judge.
Okay, thank you. The court will enter a not guilty plea on behalf of Mr. Turner. Mr. Ragnar, your position as relates to bond.
Well, people are going to ask for a $500 personal bond, Your Honor. Mr. Turner is 82 years of age. He got in an argument with the complaining witness who he was living with. She told him to leave. He gets to the door outside. He throws a bag at her, and she maced him at that point. So that's the extent of this case. So $500 personal bond. Thank you.
Okay, is there any objection, Mr. Reagan?
There's not an objection to that. I would object to the facts as they were, alleged facts as they were stated, but no objection to the bond, Judge.
I'm
Okay.
not sure the right person got charged, Mr.
Okay, all right, the court is gonna set $500 personal bond. So, Mr. Turner, that means you don't have to post any money. But while you're on bond, sir, hold on. Cannot have any contact directly or through a third party with Loretta Dingle. And you may not enter the Canfield address. Is he at the same building?
Judge, he is not.
He's not, okay. Cannot enter the Canfield address, apartment 409. You understand that, sir?
Yes, ma'am.
Okay. Hold on a moment. Okay, Mr. Turner, you have a pretrial, that's scheduled for February the 21st at 8:30. And that will be before Judge Jones, and that will be by Zoom. So make sure you get the instructions and your paperwork before you leave the jail, okay?
Yes, ma'am.
All right, sir, so you understand your bond conditions and your next court date.
Well, I need someone to probably write it down for me.
Okay, they'll give you some paperwork before you leave the jail, okay?
Yes, ma'am.
All right, Mr. Ragnar, anything further?
Nothing further, Your Honor. Thank you.
Okay, Mr. Reagan.
No, Your Honor, thing.
Okay, then we're done, Mr. Turner. Have a good day, sir.
Yeah, thank you, ma'am.
I'll just write about it.
Huh?
That's right, whatever
You know, just like this,
Good. Good afternoon, sir. Would you state your full name, please?
Michael Lewis Vance Senior.
Okay, thank you. Calling case number 25-05581-201. The people of the state of Michigan versus Michael Lewis Vance. May I have the appearances from the people first?
Good afternoon, Lisa Coyle appearing on behalf of the people.
Right, on behalf of Mr.
Defense.
Vance, David Lee Samuel, who's been advised of his rights, Judge.
Okay, the court will enter a not guilty plea on behalf of Mr. Vance. Ms. Coyle, my recommendation.
The people are asking for 20,000 cash surety, tether, house arrest, no contact with the complainant, Ms. Cook. They have a dating relationship. Allegedly on this, at this occasion, he was drunk. She indicates that he uses crack cocaine. So there's some sort of substance abuse issue going on, that allegedly he came to the point he choked her and threw her to the ground. And she suffered a broken arm as a result of his violence. She also is 60 years old, Your Honor. People believe this just occurred on the 9th. Today's on the 11th. People believe Mr. Vance is a danger to, Mr. Vance is a danger to Ms. Cook. So I'm asking for also no contact as well.
Okay, what's your position, Mr. Reagan?
Oh, Judge, I'm asking for personal bond. She came over to his house. He says, you know, it did not happen that way, Judge. You know, obviously, you know, we get one side of the story. Judge, I would point out that, you know, he doesn't need to have contact with her because he was in his house. She came there. He's worked at Stellantis Chrysler for 14 years. He's a team leader. You know, I don't know of any assaultive history that he has. Judge, he's 60. You know, they have a dating relationship, I believe, as Ms. Coyle says. You know, so asking the court to grant a personal bond. I don't know of any other allegations that have been like this before. No alcohol, maybe, if the court feels that alcohol had anything to do with this. But you know, my client states that she's always saying to him she's going to do something to have him lose his job, and she's, you know, saying certain things now. Let me look, Judge, because it's important to note one thing. Let me just make sure. Let me say, that's all, Judge. Just asking for the personal bond. I just wanted to double check one thing.
And he's employed at Stellantis. What are his work hours?
He works from, what are your work hours, Mr. Vance?
10 p.m. to 6 p.m. in the morning, 6 to 7 days a week.
10 p.m. to
6 in the morning.
6 a.m.
6 a.m.
Yeah, 6 a.m.
Okay. Parties do not reside at the same address, correct?
No, Judge, this allegedly happened at his house. She came over to his house.
Okay.
They do not reside at the same address. That's correct.
Yeah, he came over, my understanding, and they had an argument. that
Okay.
escalated to an assault.
Are there any prior convictions, Ms. Coyle?
I see a drug conviction from 2015. Felony drug conviction.
Court is going to set bond in the amount of $20,000 personal. Mr. Vance,
Yes,
during the
ma'am.
pendency of this case, you are not to have contact with Denise Cook, and sir, you're not to possess or purchase a firearm or any other dangerous weapon. And you're not to use alcohol. One moment.
Okay.
So, Mr. Vance,
Yes,
you have 2 court dates, sir.
okay,
You have a probable cause conference that is scheduled for February the 18th at 8:30. And then you have a right to a preliminary examination that is scheduled for February the 25th at 8:30. Your probable cause conference on the 18th is by Zoom. Your preliminary examination on the 25th will be in person before Judge Jakay in the 36th District Court. Sir, do you understand your bond conditions and your next court dates?
yes, ma'am. Yes, ma'am.
Okay, so is there anything further from the people?
No, Your Honor, thank you.
Okay, how about you, Mr. Reagan? Anything further?
Nothing further.
Okay, this concludes this matter. Mr. Vance, you may step aside, sir. Have a great day. Okay, we're gonna do the. Wait a minute. Okay. Sir, would you state your full name for the record, please?
Edwin Roosevelt Rancher.
Good afternoon, Mr. Renter.
Afternoon.
Calling case number 25-04443001. The people of the state of Michigan versus Edwin Roosevelt Renter, Rincher. Appearances, please.
Samuel A. Ragan for the people, Your Honor.
Right on behalf of Mr. Renshaw, Your Honor, waive the reading stamp mute. He's been advised of his rights.
Okay. The court will enter a not guilty plea on behalf of Mr. Renter Mr. Ragnar, what's your position as relates to bonds?
We're asking for $25,000 cash personal bond. We're also asking for a tether with home arrest or curfew if he is employed. Since incident happened, Your Honor, where the sister, who is the complaining witness in this matter, was assisting the defendant in filling out some information for a social security card when he didn't have the correct number. She asked him if he had another number, and of course he got upset with that and got loud, and then she went in the living room. The defendant follows her and was spitting while he was yelling and struck the complainant in the head with a closed fist. The complainant stated that the defendant eventually got her to the ground and kept hitting her. The defendant slammed the complainant on the ground and she hit her head. After the fight took place, complainant was throwing up a lot of blood, and the complainant was told by the hospital staff that she has a small brain bleed, which she needed to get some CT scans tests done to see the severity of it. Got a long history of assaultive behavior, police assaults, at least 3 convictions, and other controlled substances, Your Honor. But I think he's a danger to his sister, and apparently he's been a danger to the police as well. So I think a tether with a curfew would be appropriate with a $25,000 bond. Thank you.
You mentioned other convictions. What are they and what years?
Well, 82912 police assault, 82813 controlled substance and retail fraud. Police assault, 8720. 2 counts of police assault convictions and a retail fraud conviction. 12015 retail frauds. So that's it, Your Honor. Thank you.
Okay, thank you. Any further response from you, Mr. Ragnar? I mean, Mr.
Nothing further.
Reagan.
Thank you, Your Honor.
Judge, what was the request from the people? What type of bond was requested?
25,000.
Personal bond.
Oh, okay.
Oh, you requested a personal bond.
Right.
Right.
Okay.
With
Yeah,
a tether.
I agree with him. Judge, Mr. Ragnar got some, yeah, I agree with Mr. Ragnar. It was a system, Judge. He says he never put his hands on her, Judge, at all. Now, she has a cyst, she's had a cyst on her stomach, and she's getting ready to have surgery on her stomach. And that's why she was actually coughing up blood. It's not because of anything else. It's definitely he put his hands. I never put my hands on my sister. We argue, but I never put my hands on my sister. So I'm asking for the personal bond, Judge. My client works every day at Chrysler. He's been there a while. He's got a 15-year-old child, lives in the city. He's gonna go stay with his cousin. He say, we need let's relax, cool out. Let's no more arguing. Let me go stay with our cousin, and I'm just asking for the personal bond. I don't think a tether is necessary, Judge.
Just one additional thing. I'm not sure
Yes.
I think hospital might be medically, trained to determine about brain bleeds and things, I think.
Yeah, they may be. I don't know if that applies here, though. I don't know.
Well, the court is not here to determine the facts. I'm here to determine bond. Mr.
Right.
Reagan,
Yes, Your Honor.
what hours does your client work?
He works Monday through Friday, Your Honor, 6 a.m. to 2:30 p.m.
And he resides at a different address from the sister?
He's going to, Judge. He's gonna go stay with his cousin.
Okay.
So he has no issue with no contact because he's gonna go stay with their cousin. They were staying together, but their brother and sister. But now he's like, I go stay with our cousin, so it's no issue. We told him no contact. We already told him we're not gonna have contact.
One further question, Mr. Ragnar, is
Yes.
he currently on probation or?
Not that I could find, Your Honor.
Okay. Okay, the court is concerned. This is a very serious matter. It's a misdemeanor charge, but it's very serious in terms of the alleged injury that is reported here. The court is gonna set bond in the amount of $25,000 personal. One moment.
And Judge, can I just point out real quick, it's not even an aggravated assault case. It's not no aggravated injury. It's an assault and battery. So that tells you something in how it was charged. I just wanted to say that. Thank you.
Yes, thank you for that. One moment.
We don't have anything to do with how they're charged, Mr. Ray, as you know.
We don't have anything to do as an investigator's report either, Mr. Ryan.
You're right about that. I know.
Okay, thank you. Okay, the court has heard the arguments of the parties, had an opportunity to review the investigator's report as well. In light of the fact that Mr. Renter, he's not currently on probation or parole, he's charged with a 93-day misdemeanor. He does, according to his counsel, have somewhere else that he could reside. So the court, and he's working. The court is not inclined to impose a tether. However, Mr. Renter.
Yes.
Sir, listen, okay. During the pendency of this case, I understand this is your sister, but while this case is pending, you are not to have any contact with Ariana Matlock. You understand that, sir?
Yes, I do.
And then you're not to go over to the Gable Street location. You understand that?
Yes, I understand. I do.
Okay,
Thank you.
so hold on 1 minute. Okay. Also, Mr. Rencher, while this case is pending, sir, you may not possess or purchase a firearm or any other dangerous weapon.
I don't have no weapon. I don't have no weapon.
Okay,
Okay.
okay, so it should be easy for you to follow those conditions, right?
Yes, yes, it is.
Okay, so again, court is setting the bond at $25,000 personal. One moment. Okay, Mr. Rencher, you do have pretrial that is scheduled for February the 21st at 8:30. That will be by Zoom before Judge Jones. And you should receive some paperwork before you leave the court with the Zoom information. Okay, sir?
Okay.
All right. Is there anything further from you, Mr. Ragnar?
Nothing further. Thank you, Your Honor.
Okay, how about you, Mr. Reagan?
No, Your Honor. Thank you.
Okay, Mr. Rencher, sir, we're all done. Have a good day.
You too.
Okay. Oh, forgot about the walk-in. Okay, sir, would you state your full name, please?
Richard Hudson.
Mr. Hudson, okay. I did everything. Okay. Good afternoon, Mr. Hudson. Okay, sir, you have some traffic tickets and some other matters. We're going to start first with the traffic tickets or ticket. Because you failed to appear, there was a bench warrant that was issued for you. The court is going to set the bench warrant aside. You have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. If you can't afford an attorney, one will be appointed for you. The tickets you have, or the ticket you have, is U-506-72819, and it is for entering a vacant dwelling without permission. And that is alleged to have taken place on October 20th, 2019. So, sir, the court, for those ticket, or for that ticket, you could face up to 93 days in jail and or be fined $500. The court is going to set a personal bond in this matter, and you have a pretrial that's scheduled for March the 11th at 8:30. That'll be by Zoom, and that's before Judge Millhouse. Okay?
Yes.
All right. Now, would you state your name again, please?
Richard Hudson.
Calling case number 25-0558-1801. The people of the state of Michigan versus Richard Charles Hudson. Appearances from the people.
Magistrate, good afternoon. Always a pleasure to see you. Steve Vincent for the people, P71917.
Your Honor, right now, the Hudson waive the reading stand. He's been advised of his rights.
The court will enter a not guilty plea on behalf of Mr. Hudson. Mr. Vincent, my recommendation.
Magistrate, I would be remiss if I didn't tell you this. Defendant's one of the scarier individuals to ever set foot in this courtroom. The allegations are pretty much no different here. A clear and concise reading of the investigator's report will show you the same, why he got here and why the people feel this way about him. In addition to the allegations here, the defendant's been previously convicted of 11 felonies. Those felonies range from assault with intent to do great bodily harm, less than murder, all the way to unarmed robbery. It is interesting because in the HAB notice, there are 10 of the 11 convictions that are noted, but the 11th arguably is the most important, which is an unarmed robbery that the defendant was paroled on, as well as 2 other felonies that he was paroled on in 2024. He's going to be on parole until late 2025. But that last unarmed robbery conviction that he ended up being convicted of in 2022 sets the standard for the people asking for remand under this matter. Remand being 6.106, uppercase B, the number 1, lowercase a, lowercase I, uppercase A. The defendant currently is on parole for a violent felony, and he's being charged for this violent felony. You can see the allegations. I won't recite them to this court, but based on the criminal history, based on the fact that he's on parole, based on the fact that he's on parole for a violent felony, and now we have a violent felony before you, we feel as though remand's appropriate.
One moment.
Oh, because this. And then this is it.
And what's the status of the parole violation, Mr. Vincent, if you know?
I don't know. What I did was I ended up going to Macomb, and then I cross-checked it with the MDOC website. All that I have information on is the fact that he was paroled on that unarmed robbery, as well as the 3rd CW conviction and the retail fraud first, December 11th of 2024, only about 2 months ago. And he would be discharged from supervision December of 2025.
Mr. Reagan, your
Yeah.
response, sir?
There are only a few cases that I think, should be, in my opinion, remandable. This isn't one of them, especially in this situation. Now, I don't know about any violation, Judge. I do know Mr. Vincent's correct when he talks about my client being on parole and when he was paroled a few months ago, Judge, and he's not due to get off parole, like Mr. Vincent said, to the end of December. But this is a situation, Judge, where there's a woman, I guess, and she's dating him and his brother. She admits, she's dating him and his brother. And, whatever's happening with parole, Judge, is going to have to happen. These allegations, Judge, my client says aren't 100% true in terms of the way they are written. And we went over the allegations. We went over everything within the investigator's report. A lot of this stuff he's saying is made up because of the relationship between, her brother, his brother, and her, and trying to possibly get him out of the way at this point. Now, there was another complainant, Judge, that the police tried to contact, that they were unsuccessful in contacting and didn't answer the phone. And so I don't know what their status is. The first complaint says she doesn't want to proceed with it. So I don't know how far this case will go, Judge. I just know that, he's going to have some parole issues just simply because he picked up this case while on parole. I just don't know what the status or level of those problems will be. But right now, I don't even know if there is a hold, Judge. And he works every day, Monday through Friday, 8 a.m. to 4 p.m. at Detroit Training Center. He does machine operation. He operates machinery. And Judge, I don't know what's going to happen. I just know that while this case is pending, not to have any contact with her. I don't think he does at this point. I think that, the brother is the one that I guess she's going to be dating. I don't know. But Judge, she's not going to have contact with. Now that she's expressed the fact that she's dating him and his brothers, it's probably done with. So I'm asking for whatever bond the court said. I don't think a remand in this situation, Judge, is appropriate. But whatever the bond the court says, Judge, we just ask it be reasonable, and we ask that he be allowed to go to work, continue his job, and whatever happens on the receiving and concealing stolen property case he's on parole for, let that's going to happen, Judge.
Just to be accurate here, he's not on parole for receiving and concealing. He's on parole for 3 different convictions, none of which are receiving and concealing.
Okay. That's what my notes say. I'm sorry.
And the 3 that he's on parole for, is that the robbery not armed? One of those?
Yeah, that's from 22, the CCW from 16, and then in between that is the retail fraud one. Most recent
So
being
those-
the unarmed robbery.
Okay. Okay, the court is not going to set a order remand, but the court is going to set bond. In the amount of
Magistrate, before you do that, if you are going to be setting a cash bond, we would be recommending $1 million based on the allegations here of this defendant and the desperateness that he's shown.
Okay, thank you. The court is going to set cash surety bond in the amount of $75,000. Mr. Hudson, sir, while this matter is pending, you are not to have any contact with Carly Archel, Carlos Howell, or Jennifer Freund, Freund. Also, sir, you are not to enter the address on Maross, ending in 909. You understand that?
Yes. These allegations is false, man.
Mr. Hudson, hold on.
Okay, Mr. Hudson,
Hold on.
thank you. So the court set a cash bond based upon the clear and convincing evidence standard. These are very serious charges. And Mr. Hudson, he does have a parole hold. I'm assuming, correct, Mr. Vincent, there is a parole hold?
I haven't seen any, but you, based on what you had just said, you would assume so. I hate to assume, but based on the fact of the three, convictions that he's on parole for, that it would be natural.
Okay, and also, the court would like to add another condition that in the event that he is released on bond, that he must inform his parole officer of this case within 24 hours upon being released.
Parole officers.
Officers.
Tony,
Did you say S? Was it more than one?
I think-
Mr. Vincent?
No, sir, it's only one.
Well, I guess that
Well,
answers.
whether it's law officers or officer, make sure that you inform them of the new arrest. Okay. I think that's it. Hold on one moment. Mr. Reagan, is that bond affordable or unaffordable?
Unaffordable, Your Honor.
Okay, then there will be a bond redetermination hearing set for Thursday, February the 13th. And that will be before Judge McConicle or Judge Williams by Zoom at 9 a.m. Mr. Hudson, sir, you have 2 court dates. You have a probable cause conference that's scheduled for February the 19th at 8:30. That will be by Zoom. And then you have a preliminary exam. You have a right to a preliminary examination, which is scheduled for February the 26th at 8:30. That matter will be in person before Judge Jakay in the 36th District Court. Sir, do you understand your conditions of bond
Yes,
and your next court, and you understand when you're supposed to be back in court?
yes.
Okay, anything further from you, Mr. Vincent?
No, thank you, Magistrate.
Okay, how about you, Mr. Reagan?
No, Your Honor.
Okay, then this concludes this matter. Mr. Hudson, you may step aside, sir. Have a good day. We do have a walk-in, let's see, this is one person's all right. No, this is the whole,
Yeah. Oh, yeah, we're gonna get
for
the. Okay.
Sir, would you state your full name for the record, please?
Lester John Mosley.
Oh, that's Mr. Mosley. Okay. Good afternoon, Mr. Mosley.
Good afternoon.
You have 2 matters and you also have some tickets. So we're gonna deal with the tickets first. Because you failed to appear for a court date or dates, there was a bench warrant that was issued. Court's gonna set aside the bench warrant. Sir, you have the right to remain silent. Anything you say can or will be used against you. You also have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. Calling ticket number SP 1230836. Date of offense 7/30/2021. And that is for driving with license suspended, no insurance, and unregistered vehicle. Hold on. You also have ticket number 204815141. The date of offense is 4/30/2020. And that's for no operator's license on person. So the court is going to set a personal bond on those matters, and you have a pretrial that's scheduled for March the 20th at 8:30. That will be by Zoom before Judge Wagner. Okay, so you understand that
Okay.
court date?
Yes.
Okay, then we're gonna get to your other matters. Okay, so you have 2 other matters. We're gonna start with one case first. I need you to state your name again for the record though, please.
Lester Mosley.
Calling case number 25-055-753-01, the people of the state of Michigan versus Lester John Mosley. For the people,
Coyle appearing on behalf of the people.
We'll bring it on behalf of Mr. Mosley, Your Honor. Waive the reading, stand mute. He's been advised of his rights, Judge.
okay, good afternoon. The court will enter a not guilty plea on behalf of Mr. Mosley. Ms. Coyle, is there a bond recommendation?
Yes, Your Honor. Is this the AWIM or the CCW? I'm sorry, I didn't hear the case.
This one is the CCW.
Oh, with the CCW, Your Honor, I'm asking for no objection to a personal bond in that matter.
No objection, Judge.
Court will set a $5,000 personal bond in the case number ending in 753, that's the CCW. Mr. Mosley, while you're on bond, sir, you're not to possess or purchase a firearm or other dangerous weapon. Is that understood?
Yes, ma'am.
Okay, hold on. So, Mr. Mosley, you have 2 court dates on this file.
That's different days. Okay.
You have a probable cause conference that's scheduled for February the 18th at 8:30. That will be before Judge Robbins by Zoom. You have the right to a preliminary examination. That is scheduled for February the 25th at 8:30. That will be in person before Judge Giles in the 36th District Court. Sir, do you understand your bond conditions and court dates relating to this case?
Yes, ma'am.
Okay. You have another matter. Okay. Sir, I need you to state your name again.
Lester Mosley.
Okay, calling case number 25-055-429-01. The people of the state of Michigan versus defendant number 1, Lester John Mosley. Appearances, please.
Coyle appearing on behalf of the people.
Bring it on behalf of Mr. Mosley, Your Honor. Waive the reading, stand mute. He's been advised of his rights.
Court will enter a not guilty plea on behalf of Mr. Mosley. Ms. Coyle, bond recommendation.
Honor, this case is a reissue. The original bond was $250,000 cash, tether house arrest. It was taken to a redetermination hearing on the 14th of April of last year. It was upheld. That bond was continued. I do know that this case, on May 8th of 24, the complainant came in late. She had car trouble and arrived late, but the case had already been dismissed at the exam. This case then was reissued. I do note in the APA file, they're dated the day after the dismissal, which would have been May 9th. The complainant said he was attacked again on the 8th after the defendant was released that evening from the Wayne County Jail. I also do note that this is a case in which the complainant felt it's an ongoing thing. The co-defendant is the complainant's ex-wife. And the motive was that she allegedly believed that the complainant stole something from her car. So this is at his barber shop. His belief was they were waiting in ambush for him. There were 9 shots fired allegedly by this defendant from inside the ex-wife co-defendant's car. Police collected 5 9mm casings recovered at the scene. The shot spotter also detected 10 shots at that location and at that time. The complainant picked the defendant out of a photo show. The defendant has a prior assaulted record. He has a 2012 B&E motor vehicle under HIDA, and a 2014 unarmed robbery under HIDA. He also picked up this CCW. The original date of this was January 9th of 24. This CCW was of April 11th of 24, in which officers see him with the hoodie, and they ended up getting, they believed he had a weapon. They chased the car. He was not the driver. It appeared that he tossed a gun into a recycle bin. He denied in his statement to the police that he ever touched the gun. They did DNA on that gun, and they recovered DNA that matched the defendant. So that shows that he has access at least to weapons. Based on the severity of what's going on, based on the fact that after he was released on the 8th, although I don't know of anything since, but this case was reissued, and based on the seriousness of it, that there's not only corroborating evidence, the spot shotter, the 5 casings recovered from the location. We have the photo show he does not really know him. He knows the ex-wife, allegedly, is what I gleaned. And based on that, Your Honor, I believe he is not only a danger to the complainant, but he is a danger to the community. And so for those reasons, Your Honor, I'm asking for that high cash bond with a tether to be also to remain in place.
The dollar amount that you were requesting,
I'm requesting the same dollar amount with the tether house
that
arrest.
250,000 that was before?
It was 250,000 cash. No objection to a cash surety.
Mr. Reagan, your position, please.
Yeah, Judge, I do understand he's charged with CCW and that there was DNA allegedly, it was supposed to say on that particular case. Doesn't have really anything to do with the AWIM case, Judge. But you know, you can't have it both ways, Judge. And I understand what Ms. Coyle's saying, and I'm not saying this in any way, shape, or form personally to Ms. Coyle, but you know, I've seen cases dismissed, and she claims that the complaining witness had car trouble. He didn't show up on May the 8th. The case was dismissed without prejudice. I've seen cases go right across the street and get reissued right away. This wasn't reissued again, Judge, until January 23rd of 2020, which was a couple weeks ago. So I don't know about the urgency of having this case reissued and the complainant still wanting to go, you know, forward hard with it. I don't know, Judge. I mean, I can't speak on any specifics of why anything happened or didn't happen, but I'm just looking at the dates and the times of when it was put back in. You know, nothing's happened, like Ms. Coyle said, you know, to my knowledge, since May the 8th, nothing has transpired between now and January 23rd to make it be reissued. You know, so Judge, I don't think a high cash bond is necessary. He has a personal on the CCW. That's a newer case. The other case, Judge, you know, it's going to go through the system. What happens at exam now? You know, if the complainant shows, he shows. If he doesn't, I don't know. But as Ms. Coyle said, there is some type of relationship between, I guess, the co-defendant and the complainant and my client. Some type of triangle relationship, possibly. I don't know.
Ex-wife. She's the ex-wife.
Ex-wife. So yeah. So you know, Judge, you know, it's not strangers. So you know, I don't know if my client did any actual shooting. I don't know what actually happened. I wasn't there. I just know it's going to play out in court, Judge. And again, since May the 8th or May 9th, I don't know after that, Judge, you know, if anything that my client's been involved with the complaint, it seems like they're quiet on the home front. So I'm asking the court to take that in consideration. My client works every day. He's a high-low driver, Judge, 6 a.m. to 2:30 p.m., Monday through Friday. So I'm asking the court to take that time lapse in consideration when setting bond. I don't think a high cash bond is necessary in this particular situation.
But I'm just going to clarify a few points that I think I know from reading the IR that said that the complainant does not really know this defendant, my understanding. They had to, for him, they had to go for a Facebook page and find through a friend or whatever. They went and found it, and they found the use of the Facebook video. They matched him through the SOS photo, his Secretary of State photo, and that's how they figured out who it was. the complainant doesn't know this man. He knows the ex-wife. And so this seems like the middle person is the ex-wife who's putting up possibly the defendant to do the dirty work that he's shooting out the side of the car allegedly, and that she's driving that vehicle. So it's not like the complainant knows him personally. It does not appear that way. Like I said, the motive potentially was that the ex-wife believed he stole some items out of the ex-wife's car. And that was back in, I think it was January 10th, something around there. And so, no, that's when they talked to her. And then on the 12th is when they found the Facebook photo. And then he then picked him out of a photo show on the 18th of January. So that's how it kind of all fell in line. Your Honor, I look at it this way, whatever it is at this point, I'm asking for that high cash bond, if not a 250, at least 100,000 based on the severity of the shooting here. We do have bullet holes in his vehicle. So it obviously those bullets were aimed for him. So as Mr. Reagan says, it will play out in court. We're not here to evaluate. We're here to look at the danger of the community or flight. And so I'm asking, based on the danger to the community, for a high cash bond with a tether. Thank you.
And Judge, based on that relationship in terms of the ex-wife knowing the complainant, that makes me even think more that the complainant would know who her husband is. I mean, if he has a relationship with the ex-wife. So to say that he might not personally know him, but I'm sure, Judge, if he knows his wife, he probably has some idea who her husband is based on, and I can't say for sure, Judge, but I'm saying that just makes sense. If they have a relationship, complainant and the ex-wife, then he might know who she would be married to, or see who she would be married to, Judge.
Are they married?
No, you said it was his ex-wife, right?
No, the ex-wife and the defendant. Is that what you're saying?
You're saying the
ex-wife is of the complainant, not the defendant.
Okay, I'm sorry.
The co-defendants are not married.
Okay.
The ex-wife was married to the complainant at one time. That's my understanding.
But you're saying she's putting the defendant up to to do something to the complainant. So if that's my thing, if the ex-wife knows both parties, somehow she ties everybody in together. Not
she was driving the car.
Yeah, not personally, but I'm sure.
Okay. You can argue those points. You can argue those facts in court, but not for a trial, not right now.
Right.
I do have an additional question, though, and I do appreciate your arguments. Mr. Reagan, you indicated your client was working. What is work hours? And where is he working?
He's a high-low driver. Monday through Friday, I have 6 a.m. to 2:30 p.m. Where is the exact location of where you work, Mr. Mosley?
Magnum.
Magnum. Okay. And then how did he get arrested?
He was at home, Judge. They signed this warrant. He probably, I don't know if he even knew it was signed some 6 months later, and they came to his house and picked him up, Judge.
Right. The warrant was signed in November. It was entered in January. That is correct.
Okay. So have you heard the arguments? And I appreciate the input from both parties. The court is going to set bond in the amount of 100,000 cash surety. There were, or is alleged that multiple shots were fired in this case. And it's alleged that Mr. Mosley is the individual that fired those shots. The shots being fired was also corroborated by shot spotter to that particular location. Does have some prior assaultive offense. And the court believes that he poses a danger to the complaining witness. And the findings of the court by a clear and convincing evidence standard. Okay, so Mr. Mosley.
Yes.
Sir, while you're on bond, you may not possess or purchase a firearm or any other dangerous weapon. You may not have any contact with Ashante Smith, the complaining witness, correct, Ms. Coyle?
Yes, Your Honor.
Oh, that's not, okay. All right, so those are the conditions. Hold on one moment. Okay. Mr. Mosley, sir, you have 2 court dates. You have a probable cause conference that's scheduled for February the 19th at 8:30. And you also have the right to a preliminary examination, which is scheduled for February the 26th at 8:30. Your court date on February the 19th will be by Zoom, and your court date on February the 26th will be in person before Judge Jakay in the 36th District Court. Mr. Reagan, I forgot to inquire, is that bond affordable or not?
Unaffordable, Your Honor.
Unaffordable. Then you will also have a bond redetermination hearing that will be set for Thursday, February the 13th at 9 o'clock before Judge McConicle or Judge Williams. Okay, Mr. Mosley, sir, you received a lot of court dates, so make sure that you get your paperwork from the jail before you leave, okay? Make sure that you make your court dates. All right. And the bond redetermination hearing will be by Zoom. Okay, Ms. Coyle, is there anything further?
Nothing further, thank you.
Okay, Mr. Reagan?
On this case, Judge. Thank you.
Okay, thank you. Okay. We're gonna do this last person that's in custody, and then we're gonna do the walking and serve. So thank you for your patience. Also, Mr. Vincent, thank you for your patience. Okay. Sir, would you state your full name for the record, please?
Damon LeVar Simmons.
Okay, good afternoon, Mr. Simmons.
Good
Mr.
afternoon.
Simmons, you have some tickets, and then you have another matter. We're gonna address these tickets first. Because you failed to appear, there was a warrant that was issued for you, sir. So the court is going to set that warrant aside. You have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. And if you cannot afford an attorney, one will be appointed for you. Calling ticket number SP 1270480. In this matter, that's October 28th, 2021. The violation is for driving with the license suspended and no insurance. Okay. So for those matters, you could face up to 93 days in jail and or $500 fine. Court is going to set a personal bond for the tickets. You have a pretrial that's scheduled for March the 11th at 8:30 by Zoom before Judge Archer. You understand your court date relating to the tickets?
Yes.
Okay. Now we'll get to your main matter. Would you restate your name for the record, please?
Damon LeVar Simmons.
Calling. Hold on. Yeah. Mhm. And I think she said it couldn't get him. Okay. Yes. Okay. It's Nancy, it's okay. It was an alias, it's on the ROA. Right, okay. Okay. Calling case number 13055560001. The people of the state of Michigan versus Damon LeVar Simmons. Appearances, please.
Samuel A. Reagan for the people, Your Honor.
Reagan on behalf of Mr. Simmons, Your Honor, who's present for arraignment, waive the formal reading at this time.
Okay. The court will enter a not guilty plea on behalf of Mr. Simmons. And we call the warrant in this matter. So, Mr. Simmons, you were scheduled for a preliminary examination back on February the 1st, 2013, sir. At that time, it was before Judge Lydia Nance Adams.
Excuse me, could you read?
36.
Well, hold on,
Yeah,
let her.
February 1st, 2013. You failed to appear for a preliminary examination in this case. And when you didn't show up, Judge Lydia Nance Adams set bond in the amount of $5,000 cash.
So Judge, this is what
And-
Judge, oh, I'm sorry, go ahead. I'm sorry.
Let her finish.
That was the exam that was set.
Right.
That was who the exam was before, according to the Register of Actions. Okay. So it's his court date is going to be before a new judge, but that was who set the cash bond. And the court clerk attempted to reach out to Judge Jefferson regarding the bond. It was not able to, so the bond will remain the same at $5,000 cash. I have no authority to change that bond,
Right.
Mr. Simmons. So there will be a bond redetermination hearing set. Oh, I'm sorry, Mr. Reagan, is that affordable or unaffordable?
That's unaffordable, Judge. That's not unaffordable here, but I just wanted to make a record of everything that happened in this particular case. That's all, once you do that.
Okay, make a record. Go ahead.
No, I'm just saying, this was a case, Judge, that was picked up by federal agents. Back then, he did 6.5 years on this particular case. I don't know why it wasn't dismissed. He had 2 years probation after the fact. But for whatever reason, this case still appears in our system. That's something I know I would have loved to have told Judge Jefferson or had her know that information so that, we could have had a chance to probably argue that and let her know what was going on. But I just wanted to make a record of that right now, Judge, and we'll have to, I guess, at a later time, in front of Chief Judge, we'll have to, make that argument and deal with it at that time. But I just wanted the court to know that this is the case that he, that he was picked up by the federal agency, Judge, and resolved back in 2013.
Okay, well, the documentation is not currently before the court, and so you could certainly, or your office could present that argument at the next court date. Mr. Simmons, sir, while you're on bond, you're not to possess or purchase a firearm or any other dangerous weapon. Sir, do you understand your conditions of bond?
Yes.
Okay. And based upon the current charges, sir, you have 2 court dates. There's a probable cause conference that's scheduled for February the 18th at 8:30. And that will be by Zoom. Then you have a right to a preliminary examination, which is scheduled For February the 24th at 8:30, that will be in person before Judge Jefferson in the 36th District Court. So, Mr. Simmons, sir, do you understand your bond conditions and your court dates?
Not fully, but yeah, I guess so, but I don't want to be a hassle.
No, sir, I have to make sure you understand. I'm not talking about the facts of the case. I'm only asking whether or not you understand when you have to return to court.
Yes, I understand that.
Okay, and your bond condition for no weapons. You understand that?
I don't play with weapons, believe me.
Okay, and then you have a bond redetermination hearing that is scheduled for Thursday, February the 13th at 9 a.m. and it will be before Judge McConicle or Judge Williams. So what you don't understand, they will give you some paperwork before you leave the jail. Make sure you pay attention to all those dates and read the paperwork as well, okay?
Okay.
All right. Mr. Ragnon, is there anything further from you, sir?
Nothing further. Thank you, Your Honor.
Okay, how about you, Mr. Reagan?
Nothing further, Your Honor.
Okay, this concludes this matter. Mr. Simmons, sir, we're done. Have a good day.
Thank you, Your Honor.
Didn't I give it 13?
I thought you did.
Oh, I got it right now. Here we go.
DVC will
That's
meet you
all.
on the female side.
That's all the men we have. We'll meet you on the female side.
Thank you, sir.
Okay, we do have a walk-in. Are we gonna go
Yeah,
ahead?
we have to break. I gotta zoom in. on the female side.
Oh, okay. So, Mr. Vincent, we're gonna do the walk-in. Okay,
Okay, thanks, Magistrate.
right. Yes, we saw your chat. One moment, please. I know that's what. Okay. Step forward, Mr. Bruton. All right, and Mr. Reagan, your office has had an opportunity to talk to him, correct?
Correct, Your Honor.
Okay. All right, sir, would you state your full name for the record, please?
Yes, Myron Bruton.
Okay. Calling. Case number 25-05545-401. The people of the state of Michigan versus Myron Lamar Bruton. Appearances from the people.
Thank you, Magistrate. And again, good afternoon, Steve Vincent for the people.
Your Honor, Philip Reagan on behalf of Myron Bruton. Waive the formal reading, Stan Muley's been advised of his right.
Okay. The court will enter a not guilty plea on behalf of Mr. Bruton. Mr. Vincent, your position on bond.
Magistrate, the people's position is we're asking for a 30,000 cash or surety bond. We're also asking for monitorization, including alcohol tethering. As you can see, the defendant's being charged with what he's being charged, which is unfortunate because he's been convicted of these charges previously 3 other times. This is actually a 4th. The most recent 3rd being in 2021 out of Oakland, including the fact that he was driving in that particular situation without a license either. He ended up spending time in jail as well as getting probation. He had gotten off of probation about 1.5 years ago, only to pick up a conviction for a gun charge. He's currently on a gun charge. He was on a gun conviction at the time of this offense. So while this is his 4th go around regarding drinking and driving, but not just that, with the high BAC, as well as him being on probation, and we can see the allegations for what they are. And I do have to stop myself here and say, this isn't a flight argument. We appreciate the fact that defendant obviously walked himself in today. But I'm sure the court, as well as the defendant, as well as defense counsel for that matter, can appreciate that we see this individual as a clear and present danger to the community. The allegations speak for themselves. He had his 14-year-old child in the car when allegedly he ends up hitting a vehicle in the early morning hours, only for the police to come. He doesn't give information to the police about his identity. It was actually his child who ended up having to give the police his father's identity. Then refusing the PBT test only for 3.5 hours later, having a blood draw based on a search warrant where it was shown he ended up having a 1.9 blood alcohol level. And again, this is his 4th go around. So being told not to drink and drive doesn't work for this defendant. And knowing not to drive without a license has no effect. And being supervised by the court does nothing because he currently is on that weapons charge. And this isn't trial. This isn't opening and closing statements and all of that. This is an argument that this defendant is a danger. He's posed a danger to the community for a long time. In this instance, only happened a few months ago, taking some time for the lab reports to come back. So it's clearly evident he's putting many people at risk here, including his own children, based on the allegations. So we're asking for that cash with monitorization as well as the alcohol tether.
Thank you. Mr. Reagan?
So Judge, it is a very serious case. Let me first start by saying that, my client as Mr. Vincent said, is on probation. He's on probation for a CCW and OWI, Judge. And I think that's important to note that he has a probation officer. He is going to start, and part of his probation on that case is to do substance abuse counseling that he's been directed to start by his probation officer. His probation officer knows about this case. Now, this case happened allegedly in August of 2024, and the warrant was signed in July. I'm sorry, in January 24th of this year, just signed a few weeks ago. So Judge, in terms of getting the alcohol tether, I think that it's imperative that he gets an alcohol tether. I think it's imperative that he be monitored in terms of having that on his ankle so that if he even thinks about taking a sip of alcohol, it will register and it will show up. And driving is out of the question. He doesn't drive now. He didn't drive down here. And as Mr. Vincent said, it's not a flight issue. And we know that. It's a two-pronged test. We talk about flight and danger. Flight's not an issue. We're talking about danger. How do you stop him from drinking and driving? The first thing you do, stop him from drinking. And you do that with an alcohol tether. As Mr. Vincent said, he was driving on a suspended license when this happened. Wasn't being monitored at the time with alcohol. So, Judge, he has somebody that drives him. He does not drive a vehicle. So what I'm asking the court to allow him to do is to give him 24 hours to go get that alcohol tether put on. Have his probation officer know about what's going on. Have his probation officer be involved in it. He was supposed to start a substance abuse class, a program. Tomorrow is what he told us, but I think the tether is more important than anything, the alcohol tether. So if you give him, the person that drives him, take him to get that tether, give him a time period. If he does not have that tether on within 24 hours, then all bets are off. He goes straight to jail. But I don't think that giving him a high cash bond here, Judge, is going to help. I think that a tether, monitoring him, would be more sufficient in this situation. Part of a OWI third, and that's what he's being charged with, even though, as Mr. Vincent said, it's a fourth, he's being charged as a third, it's going to be some mandatory jail time. Right now, Judge, I'm just concerned about him getting the tether, getting into the substance abuse program that his probation officer wants him to do, and getting through that. There's obviously an issue here, to deal with that issue, but at the same time, we want to protect individuals as well. And I think that alcohol tether can do that.
Okay, thank you both for your arguments. The court has had an opportunity to also review the investigator's report and the history of Mr. Bruton. Mr. Bruton, the court is certainly concerned about your prior drunk driving offenses. Appreciate the fact that you came in, that you walked in today. And the court doesn't believe that it's a flight risk that is at issue here. You probably come to court, but the court is concerned about you continuously drinking and driving. There was a 2017, there were two no, sir, 1 minute, I'm speaking.
Sorry.
Two drunk driving offenses in 2017 within about a 2-week span of one another. And then there was a 2020 OWI as well. At that time, I believe it indicated your license was revoked. You still don't have a license. In this case, you're also charged with, I believe, driving with no license, license suspended or revoked. And there was also a minor child in the vehicle. The charges are in the alternative as a high BAC, OWI, and impaired, all falling under the third offense notice. So the court is going to set a personal bond in the amount of $30,000. However, the court is going to require, sir, that you wear an alcohol tether, and you are going to have to be taken into custody and have that put on before you are allowed to return to the community. So you walked in, and most people that walk in will walk out. But based upon your history in these drunk driving offenses, we're charged with protecting the public. And you pose a danger to the public with the numerous drunk driving offenses. You obviously have not been paying attention to what the court has been saying, as it says, no drinking, no driving. I'm going to say it again. It's a condition of bond, no drinking, no driving. And you're not to use any alcohol as well. Some additional conditions, sir. You must inform your probation officer of your new arrest within 24 hours of being released. And you must again be connected with an alcohol tether. So that's the court's ruling. We'll give you your next court dates. Mr. Bruton, you have a probable cause conference that's scheduled by Zoom on February the 19th at 8:30. You also have the right to a preliminary examination that is scheduled for February the 26th at 8:30. That will be in person before Judge Giles. Your other matter will also be before Judge Giles on the 19th, but that will be by Zoom.
Speak at all or no?
You might want to ask Mr. Reagan,
Well, Judge,
your client is here. You want to speak or you want your client to speak? Go
Well,
ahead.
Judge, I was gonna ask, I know you were gonna ask Mr. Vincent and I, did we have anything else we wanted to say? I did have a couple of things I wanted to say. I didn't know, if this was the time for it, Judge. We appreciate.
Your client was also asking to speak, so.
Yeah, well, he definitely has a right to speak. I just would like to speak prior to him speaking, because I just,
Yes, go ahead, Mr. Reagan. Go
we
ahead.
appreciate the
And how about
court.
how about I reserve the right to speak after everybody else speaks? How about that?
Judge, and we appreciate the court, Judge. We appreciate the court, and the court's wisdom. We understand what the court's saying. I would just point out that Mr. Bruton has been doing well on his other probation, Judge. Now, if this was a situation that just happened yesterday or the day before, this was something that happened, back in August of 2024. Now, just in saying that, Judge, and my only thing is he hasn't driven. To my knowledge, Judge, he tells us he hasn't driven. He's scheduled to go into a substance abuse program tomorrow that his probation officer knows about, that has directed him to go to for his other probation. That's the only reason we were asking for the 24 hours, to allow him to get his own tether put on. We weren't trying to bypass that at all, Judge, and say that he can just go out here and be without a tether. So my thing is to allow him to do that, and to ask one more time, because he did walk in, Judge, and he's not driving. He didn't drive down here. He won't be driving, but that would just be my request, Judge. I know that.
What program was he going to go into, Mr. Reagan?
And that's a great question, Judge. That's probably the best question. Mr. Bruton, can you tell the court where you were supposed to start and when?
Yes, it's a substance abuse outpatient treatment and on Chrysler Drive, 93901. I have the phone number as well if you would like to take their phone number down, but my appointment starts tomorrow morning at 8.
Oh, it was outpatient. It wasn't inpatient, correct?
Correct.
Okay, so they'll probably be able to set another appointment for you. Okay, so, and I commend you for trying to take the initiative and get into a program. But Mr. Vincent, sir, did you have something else that you wanted to say?
No, I think the court just covered that with what she had just said regarding the adjournment and then rescheduling of the appointment, so we can get this alcohol tether on this individual immediately. So no, I stand mute moving forward.
Okay, and Mr. Reagan, he was given consideration in terms of walking in. That's why he didn't receive a cash surety bond. He received a personal bond, but he must be connected to tether, alcohol tether. Okay. Anything further from either one of you? Mr. Reagan, your client has his hand up.
Well, Judge,
again.
I just wanted to say, and I'm not trying to belabor the point. That program, was ordered through the probation department, and I'm just, making a record of that, Judge. I understand with the courts, but I want the court to know that's not something he came up with. They ordered him to go to that based on his other probation as well, Judge. I just want you
Okay, well, I'm sure that they can reschedule that, Mr. Reagan. I used to be a probation officer, so it can be rescheduled. Okay.
Thank you very much, Judge.
He's raising his hand again. Sir, how about this? Do you have anybody that's available to talk to Mr. Bruton?
Yep, we're coming right now. We're coming
Okay.
Right as we speak. Ms. Harris is coming right in there.
Okay, so Mr. Bruton, the court is not trying to suppress your speech, sir, because you do have a right to speak. But we always caution, defendant
Was
speech.
curious on how long it would take to get the tether put on the process due to my daughter having to be to school as well. And I have full physical custody of her, so I'm just trying to figure out how long it takes.
Sir, hopefully as soon as possible. I can't say that it's gonna take place today, but hopefully as soon as possible. We don't.
I'm sorry,
place those,
Magistrate, I'm
Yes.
sorry, I didn't hear that clearly. Was defendant talking about taking his daughter to school?
I don't drive. I have.
He said he had
pops
custody,
that
I believe he
drops her off
said.
and picks her up, but I have to be with her because it's a custody situation with mom. So.
Okay.
I have.
That's why, sir, say a little as possible will help. Okay, you have counsel there.
But did the court understand what he was saying, that he does not drive?
Yeah.
Okay, and that but because of a custody matter, he has to be present for the
Miss-
dropping off and picking up with his daughter. I didn't know if the court understood.
So I'm sure that there's some other arrangements that can be made while he's being placed on tether. I've given much consideration here today. And Ms. Harris, you didn't put your name on the record. Would you do that?
Yes, good
Okay.
afternoon, Christina Harris, P52857 on behalf of Mr. Lieutenant.
Yes. So Mr. Bruton, sir, everybody that comes before the court, they have different issues that are going on. But this, the court is giving you some consideration, but it's the same repetitive behavior in terms of the drinking and driving. And so, you have to be connected today, or at least taken into custody to be connected, okay? And I'm sure they'll do it as soon as possible. Give the information to your attorney and she will notify whoever needs to be notified in regard to your confinement status.
All right,
Okay,
thank you.
anything further, Mr. Reagan or Mr. Benson?
No, Your Honor, thank you.
Okay, thank you. This concludes this matter. Did I give him his court dates?
Sir? Just make sure you get my.
Did I give the court dates, Madam Clerk? I did not. Okay. So, Mr. Bruton, I need you to turn around again. I thought I might have, but maybe I didn't. We went back and forth. So you do have a probable cause conference that's scheduled for February the 19th at 8:30. And you have a right to a preliminary examination that's scheduled for February the 26th at 8:30. The court date on the 26th will be in person before Judge Giles, and the court date on February the 19th will be by Zoom. And I already covered your bond conditions. Sir, do you understand your next court dates and your bond conditions?
Yes, Your Honor.
Okay, thank you. Let's conclude this matter. You got a female, don't we?
And then just bring them in whenever you're ready.
Open slide. So I just go. Okay. I will. Okay. Okay. Not first, not the child. Okay, okay, all right, thank you.
Okay, let me see, one moment, ma'am. Oh, that was a prayer case, okay. One moment, ma'am. Okay. Okay, good afternoon. Ma'am, would you state your full name for the record, please?
Najee Respress.
Okay. Oh, hold on one moment.
This one right here.
Yes, oh, yeah, okay, go ahead. Keep moving. Okay.
Okay, calling. Oh, good afternoon, Miss, is Respress?
Respress.
Respress, okay. Calling case number 25-0444-3101. The people of the state of Michigan versus Najee Respress. Najee Respress, also known as Najee D. Respress. Appearances, please.
Lisa Coyle appearing on behalf of the people.
So right on behalf of Ms. Respers, Your Honor, waive the formal reading, stand mute. She's been advised of her rights.
Thank you. The court will enter a not guilty plea on behalf of Ms. Respress. Ms. Coyle, bond recommendation?
Your Honor, as far as Ms. Respress, I do not see a criminal history for Ms. Respress. And I don't see them having contact with each other on a daily basis type of thing. I'm asking for a personal bond with no contact.
No objection, Judge.
No objection. The defense court will set bond in the amount of $5,000 personal. Ms. Respress, while this matter is pending, you're not to possess or purchase a firearm or any other dangerous weapon. You're not to have any direct contact with, nor have anyone else indirectly contact Tanise Owens. Do you understand those two bond conditions, ma'am?
Yes.
Okay. One moment. Okay, Ms. Respress, you have a pretrial that's scheduled by Zoom on February the 24th at 8:30. And that will be before Judge Bryant. Okay?
Yes.
Okay, so you'll receive some paperwork before you leave the jail with the Zoom information. You understand your bond conditions, correct?
I'm sorry?
Do you understand your bond conditions
Yes, ma'am.
and your next court date? Okay, is anything further from the people, Ms. Coyle?
Nothing further, thank you.
Okay, how about you, Mr. Reagan? Anything further? Mr. Reagan, anything further, sir? You're on mute.
No, I'm sorry, not on this case. No, Judge, thank you.
Okay, thank you. So, Ms. Respress, we're done.
Okay.
This concludes. Okay, have a good day. DDC, do we have any males or females that are at 48 hours?
I would have to take a look.
Okay, check, let's see.
Judge, can I ask Ms. Coyle a question? Since I have Ms.
Hold on,
Coyle.
hold on.
Ms. Coyle, can I ask you a question?
So Ms. Coyle's not on it. Are you asking Ms. Coyle or are you asking?
I'm sorry.
Ms. Coyle, you had said one of the cases earlier, you said it was signed November, but it wasn't entered until
I
January.
think so. That's what I saw. Let me see. If I
That's
know. When they sign it over
How's
there,
that?
and sometimes when it
Oh,
goes back.
You
You know
know
what
what?
I'm saying?
Yeah, I know what
Talking-
you're saying.
Okay, I think,
I
I
get
know
it.
this, we're talking about entered and signed.
Yeah,
Got
I got it. I was thinking something different. You're right. I was thinking about something different. I know exactly what you mean when you said
No worries, no worries.
that.
You clear now, Mr. Reagan?
I'm clear,
Talk-
Judge.
We're speaking the same language now.
Yeah, I don't know what I was thinking something else.